Hello, everyone. My name is Lynne Golding, and I am a corporate and charities lawyer with Fasken, Martin O'Donovan, and the head of our health law group. I'm very pleased to welcome you here to the 16th annual Carter's Fasken Healthcare Philanthropy Checkup. And you heard that word, 16th, eh? Terry, it's our sweet 16th birthday, I think. If our seminar could drive, they would be 16 years old and able to get a license. Anyway, we're really happy to have you back here again. The second time we've had to hold this seminar online, but we know that actually it provides a greater opportunity for some of you to join us. So Terry and I are going to be joined today by a few other people: Theresa Mann of Carter's, Daniel Fabiano, Laurie Turner, and Daanish Samadmoten from Fasken. And I'm going to introduce all of those people a little bit with more detail in a few minutes. So first of all, let's just do a little bit of housekeeping. Just so you know, there will be an online survey that you can complete at the end of the webinar. I will remind you about it again later, but you'll see that there is a survey button underneath the video window. We really appreciate it when you complete these, as they help us determine what topics to address in the next seminar. There are a lot of materials for today's seminar, and they are available at the handout button again under the video button on your Zoom platform. We are recording today's webinar, so if you don't catch everything the first time, you can go back and listen to it again later. I have to tell you, the materials, there's a lot of information there, so do take a look at them. We've got some bulletins, we've got much more expanded biographies of the people who are attending and other background information about our two firms. You might have questions during this webinar, and if so, please just use the chat button, and we will keep on top of those. We will be answering questions as we go along in the seminar. So our speakers will make their presentation, and then there will be time at the end of their presentation to answer questions. They'll answer as many as they can before we go on to the next speaker. You might need technical support, and if so, there's a technical support chat button. Please make use of that if you need to. There are a lot of COVID bulletins and policies that our two firms have produced over the past 18 months. So there's a lot available for you at the COVID-19 Knowledge Center, which you can find on the Fasken website. And of course, the Carter's website will have many materials as well. So with that, I'm going to introduce you more formally to Terry Carter. Although the man needs no introduction at all, I'm sure you're all very familiar with Terry, who is the managing and founding partner of Carter's Professional Corporation. Just yesterday, for the fun of it, I added up all of the advisory boards that Terry has been on over the year. I stopped counting at 10 over the years, I should say, including the CRA. So Terry is very, very familiar with the CRA, and they are with him. He just makes a great resource to all of us and you, and the Carter's clients. So Terry's going to speak to us about a subject that is important right now. So we're all looking for new opportunities to create revenue for our charities. So Terry's going to speak about income generation for healthcare charities, including social enterprise and impact investing. So over to you, Terry.
Well, great. Thank you very much, Lynne. And it's a real pleasure to be with all of you today. And as Lynne said, we've been doing this now for 16 years and working together as two firms coordinating. So it's our pleasure to be with the team at Fasken's today. Just to point out that if you do have questions, I think it's a Q&A button that you go to, and we'll do our very best to answer questions at the end of each session. The issue of income generation is so important for charities, particularly for healthcare charities. And what I'm going to try to do in the next 25 minutes is provide you with sort of a high-level overview of some of the issues that you need to think through. The PowerPoint slides are fairly dense. It's intentional, so you can take a look at it at a later time, and I don't have to go into all of the details during the presentation. But we wanted to give you some context for it. So Andrew, if you can go to the next slide, please. So what I'm going to be talking about, first of all, I'll give you a bit of an overview, a survey of the different types of income generation available. And then we'll spend more time drilling into related business, unrelated business, social enterprise, and impact investing, because all of these topics are relevant to not only healthcare charities, but to all charities. And it's important to be familiar with what those issues are. Next slide, please. So again, just a brief overview over the next number of slides. When you're looking at income generation, of course, you're looking at government contracts and grants, particularly healthcare charities, with regards to what the government provides. You get income that comes in from gifts that come in from individuals and public foundations and individuals. Next slide, please. Then you can have income from fundraising events and income that comes in from third parties that do fundraising. And again, I'm not talking about any of the details here. That's not our focus for the discussion today. Income from membership fees. Next slide, please. You can also have income that comes in from sponsorships. That's an important area. It could be actually a topic of a separate presentation. It's an important one for charities to increase their income. And again, gaming, lotteries, raffles, income from conference fees. Next slide, please. And then you can have income that comes in from passive investments. And again, this is passive. So we're dealing with simply mere ownership of property, can be in the form of interest or dividends, royalties. So we'll talk a little bit more about that during the presentation. And then there's income from charitable programs. This occurs with healthcare charities in relation to, hospitals in relation to some of the charges that they have, or the sale of goods that may come up. It's perfectly fine, but your focus has to be upon serving the beneficiaries, achieving your purpose, making sure that the fees are reasonable and generally are aimed at cost recovery. Next slide. And just to round out the survey, again, just to put it into context, related business, you can do it. Unrelated business, you can't do it, but you can do it through subsidiary corporations, social enterprise. We'll talk about what it is and what you can do. And then impact investing is sort of the new buzzword that a lot of charities are looking at. So next slide. So with all of that sort of background context, now we'll go into things in a little bit more detail. When we're talking about income generation from business, we have to understand, what do we mean by business? And basically, carrying on a business is commercial activities with an intent to make a profit, and it's being done on an ongoing basis. So something like fundraising is not going to be carrying on a business because it's not a commercial activity, and it's not involved in sort of an ongoing basis of a commercial business. So when you're wanting to supplement your income through business activities, first thing you got to keep in mind is the rules that apply. Canada Revenue Agency has set a guidance out since 2003. 2003, it's almost 20 years. And that guidance is the CPS 019. Most of you are probably familiar with it, but a couple of reminders. If you're going to be involved in doing a related business, you got to make sure that you are not a private foundation. So knowing your designation is important. If you're a charitable organization or public foundation, you can be involved in related business, but not so for a private foundation. If you're not sure what your designation is, then check to see how you show up on the CRA website. I think that's an easy place to go. Take a look at some of your documentation with regards to that. Related business is helpful because you can actually make $1. It's okay. And the related business doesn't have to be tied into particularly what you do as a charity. It's intended to be related to your activities. And so the areas that you can carry on a related business falls within either substantially run by volunteers or linked or subordinate. Next slide. So we'll talk about each of those A bit of a sleeper is related business run by volunteers, because here the business doesn't have to have anything to do with the charity, but the prerequisite is that the business activity has to be carried out 90% by volunteers, technically substantially all. Some of the rulings, and our firm was involved in doing some of the rulings, clarified that the calculation of volunteers is done on a headcount basis as opposed to the number of hours worked. So do keep in mind that if you're able to run a business with 90% volunteers based upon a headcount on an annual basis, you might have a winner to work with. It could be a wonderful source of making $1 or $2. I always use the example of the PEI lobster dinners put on by churches, nothing to do with advancement of religion, but they're obviously doing well in making $1 or $2 for their charity. Next slide. Once you get beyond the substantially run by volunteers type of related business, then you get into kind of a mushy area of linked and subordinate. And this is where probably you and your legal counsel will need to go through and see whether or not what you're planning to do fits within the linkage and the subordinate. It's not easy. It is a little bit gray. So on the linkage side, you have to show some connection to your charitable purpose. It's either going to be concomitant, which I always find is a great word to work with, basically means supplement your charitable programs like a hospital cafeteria, an offshoot of a charitable program, a church having a recording of a Christmas cantata, excess capacity like a university that has extra space in the summertime, or promoting the charity or its objects, similar to a Girl Guides cookie program. Those are your linkages. Next slide, please. It's the subordinate area that's a bit problematic, because you have to be able to show that it's a minor portion. And, does that mean 10%, 15, 20, 25, 30, 35, 40, 45, 49%? No one really knows. The closer you get to 49%, the more problematic it is. So most charities tend to be more cautious in that regard. You have to show that it's integrated with the charity, can't be standalone, to make sure that your focus is on meeting your charitable purpose, not the related business. And you got to make sure that there's no aspect of an undue private benefit, i.e. that your executive director is not having a wonderful opportunity with a $2 million salary from the related business. Next slide, please. So the challenges with the related business is it's hard to know whether or not you fit within it, frankly. And again, getting advice from your legal counsel is important to give you that due diligence. But if you're not fitting easily within related business, does that mean that you're out of luck? And the answer is no, you're not. It is possible to run a business activity by a charity, charity through a subsidiary corporation. And frankly, it may be an attractive option, even if you can meet the related business side, because a subsidiary corporation can contain the liability of a particular business activity within the for-profit corporation, so that can be helpful. You can have a dedicated board that's focused on the business activity as opposed to running the charity. So there are some aspects that can be helpful. Maybe your for-profit subsidiary might be involved in becoming involved in a joint venture. So there's a number of different flexibilities that you can have by having a for-profit subsidiary. However, like everything else with charities, the devil's in the details, right? So you can't just sort of run off and say, I think I'll start up a for-profit subsidiary without understanding what the requirements are. Next slide. So the first thing to understand is if you're going to have a for-profit subsidiary to run your business in, as opposed to a related business, which is operated within the charity. Okay, so we're taking this outside the charity. then that for-profit subsidiary is going to be paying tax. It's a taxable entity. It's a for-profit corporation. But, worry not, because the amount of tax that would have to be paid can be managed quite well, because the for-profit subsidiary can make a donation up to the charity, up to 75% of net income of the subsidiary corporation. You can also have payments that are paid by the for-profit subsidiary up to the charity if there's any sort of management services provided, or maybe there are sponsorship fees or license fees. So there are ways of getting money out of the for-profit subsidiary up to the charity to reduce the amount of taxable income. And as the slide sort of makes reference, the amount of tax, again, working with your accountants and lawyers, can be kept fairly low in the single digits. So it's a cost of doing business, but it's not insurmountable. The key issue to keep in mind is whatever the charity's got, if it's going to make it available over to the for-profit subsidiary, it's going to be done at fair market value. It's going to be done on an arm's length basis. You can't have gifts being given by the charity over to the for-profit subsidiary. That would get you into all sorts of difficulties. So you need to be careful about that. Next slide, please. And then to the extent that the charity is going to make an investment in that for-profit subsidiary, it's an investment. It's going to either make a loan or it's going to acquire shares with an equity interest in it. And so then you need to be mindful. You need to be able to justify it as either a prudent investment under the Trustee Act, which we'll talk about a bit more, or it's going to be a program-related investment under CRA's guidance that, again, we'll talk about a bit more. And also be aware that any interest that your charity has in a for-profit company that exceeds 20%, it becomes a substantial interest. And then the public guardian trustee has the ability to require accounting statements and has oversight to call the charity to account with regards to that because of changes to the Charities Accounting Act. Next slide, please. You also need to be aware if you're either a public or private foundation, you can't have a more than a 50% interest unless there's a gift being made of the shares over to the charity, and the slide sets out some details on that. And as well, if you're a private foundation, be aware that there are excess business holding rules that apply. So you go into public disclosure above 2% and divestment requirements if it goes above 20%. So just keep that in mind. You need to know the type of charity that you are. From a governance and operational standpoint, the for-profit subsidiary is going to be a separate entity. It's going to have a separate board. If you're trying to get some protection from liability, you've got to be aware of crossover liability that can occur. So how you set up the board and the composition has to be looked at carefully. And it's important that the subsidiary corporation be operated arm's length basis, separate bank account, separate books and records, so that you can show to CRA, well, no, it's not the charity running de facto business. The charity is not running the business that's being run by the for-profit subsidiary. So having a for-profit subsidiary, next slide, is certainly an option for healthcare charities, provided you're careful in looking at the options. Just a brief reference, there are other types of business structures. You have a nonprofit organization, which is exempt from tax, but can't issue receipts. And the answer is not easily, because the definition of a nonprofit organization means you have to be organized and operated for any purpose other than to make a profit. So it does make it a bit difficult trying to run a business through an NPO. You can get more sophisticated and get involved with a business trust and have a corporation that is acting as a corporate trustee. And whatever income is earned then flows through to the charity as a beneficiary. So it's very tax efficient, but complicated because you've got a corporate trustee and deemed disposition rules after 21 years for trust. So it's not for the faint of heart, but it's certainly an option that can be considered. Next slide, please. Okay, so what we've talked about is related business, what a charity can do within the charity itself. We talked about unrelated business, where the income generation is being done outside the charity through a for-profit subsidiary. And so that brings up the question, well, what about social enterprise? I've heard a lot about social enterprise, and that's kind of a topic that we'd like to consider and know more about. So social enterprises emanated out of the UK back about 20 years ago. We've seen it in Canada for the past 15 years. And basically, it's a business with a heart. It's a business trying to make a dollar, but trying to achieve a social purpose at the same time. Social enterprise is not a defined term. It's not a legal term. It can be done by for-profit companies. It can be done by nonprofit to a certain extent, and it can also be done by charities. And that's really what I want to talk about. Next slide. Some of you may be aware that some provinces have taken initiatives to set up social enterprise type of corporations. In BC, there's the 3 Cs, and Nova Scotia, there's the KICs, and BC now has benefit corporations, and you can also be a for-profit company and get certification as a certified B corporation. Those are all options. In Ontario, we don't have social enterprise legislation. And that's really referred to as sort of dual purpose type corporate legislation. The government looked at it. I was involved in a panel studying it, but the government has not proceeded with it. Next slide. And I think that the important point is that you don't have to have special legislation to have social enterprise dual purpose corporations. You can do that by any type of for-profit corporation, by having share attributes or unanimous shareholders agreement that talks about maybe limitations on payment of dividends out or asset holds in relation to the investment. You can do all of that by doing some creative corporate documentation. That's because in Canada, we don't have what's referred to as shareholder primacy. We're not simply focused on shareholders' interests, as stakeholders' interests can be a factor as well. So do keep that in mind. You can set up a social enterprise if you wish. And the reference to the unrelated business through a for-profit subsidiary corporation that I referred to, you could also categorize that as a social enterprise. But do keep in mind that that entity then becomes taxable, right? So social enterprise entities, if you're going to have one, is a taxable corporation, and all the issues that I mentioned in relation to for-profit subsidiaries would apply. But social enterprise can also be done by the charity. And if it's done by the charity, then it's tax-free. So next slide, please. So I want to give some examples of social enterprise activities that can be carried out by charities, including health charities. One deals with running a social business for individuals with disabilities. And the CED guidance on community economic development talks about it. And basically, it's running a business for permanent employment for individuals with disabilities, physical or mental disabilities, where you're meeting the needs of the disabled individuals, and you can make $1, which is interesting. So that's an example. Next slide, please. Another example would be employment-related training for the unemployed, not probably all that relevant for health-related charities, but still is an option. It's not permanent employment. It's really to get individuals who are unemployed or facing a risk of imminent unemployment that they need to get back on their feet. But again, in the process, you can make $1. Next slide, please. You can also be involved in providing microloans and loan guarantees to individuals who need it in relation to getting into poverty or for further training or meeting other charitable purposes. That's been permitted since 2013 when CRA came out with their guidance. So those are examples of where a charity can be involved in doing social enterprises as part of its charitable programs. So it gives you an idea. Social enterprise can be done as a for-profit subsidiary corporation, or it can be done internally within the charity itself. Next, I want to go over to the last area that I want to speak to, and that's the area of income generation from impact investing. I'm going to take just a little bit more time in talking about this because there's a fair bit of confusion. It's sort of like, well, maybe at the board of directors, and you're thinking maybe it's time for us to get involved in the kind of the newest thing, the quote, impact investing, but you're not really sure what it involves. So in a nutshell, like social enterprise, which is a business that has a dual purpose of making a dollar and achieving a social purpose, impact investing is investing that has that kind of dual purpose. It's intended to meet a social purpose with regards to charities, a charitable purpose, but also to have some type of financial return. Obviously not much, mind you, but it still has an investment return associated with it. Next slide. So when we're looking at what charities can do, donors may be interested in maybe creating a charitable impact investment fund so that the charity can go off to make investments. Or maybe you're involved in a foundation and the foundation is, sitting on a fair bit of cash and wants to make a difference instead of just buying GICs or mutual funds, want to make a difference within the healthcare sector. Well, for the charity involved, whether it be a charitable organization or whether it be a foundation, impact investing can be in the form of either an investment through a loan to an organization, whether it be a charity, another charity, or not a charity, but again, focused on achieving the charitable purpose. Or it can be an equity interest where you acquire shares and partnership interest in the particular venture. What's really important is if you're going to get involved in doing an impact investing, you've got to understand the rules, sort of the regulatory regime. Next slide. That's what I'll walk you through now briefly. So if you're going to do an impact investing, one option is you can do it as a prudent investor. That's under the Trustee Act. And this slide gives you some of the details associated with it. You can make any type of investment a prudent investor can make, and you can even be focused on achieving your charitable purpose. Next slide. But you do need to have an investment plan in place. You need to be careful because you can delegate to an investment manager, but you can't sub-delegate down further than that, which gets exciting. Your liability protection for your board, you've got a robust provision in the Trustee Act, which is great, but you need to have an investment plan and follow it carefully in order to get that protection. So that's one option. Next slide. Then you can do a social investment, form of impact investing. That's under the Charities Accounting Act. That got amended in 2017. That allows a dual purpose of both financial return and a charitable purpose. This slide, it sets out the things that you have to do. So the statute is very clear on the requirements to do social investment under the Charities Accounting Act. So if you're not going to be a prudent investment, you're going to be a social investment, then you got to follow the rules that are set out there. Next slide, please. And some of the rules are, difficult. You can't really use endowment funds for social investments easily. And most importantly, you can't do delegation of investment decision-making. So you can't have an investment manager that you give that responsibility over to. And the liability protection under the Charities Accounting Act for social investments is not as good as under the Trustee Act. If you read it carefully, it says you'll get protection if you acted honestly and you comply with the terms of the Charities Accounting Act and the terms of trust. That's not very helpful, frankly, but it does mean you got to really read the Charities Accounting Act carefully. Again, I've given you a summary here on these slides and work with your legal counsel to comply with it. Next slide. Well, of course, if life could be simple and we just had to work with provincial provisions, that would be fine, but that's not the case. You're a registered charity. So at the federal level, if you're going to do a social investment, then you've got to think about what the feds require. And under the Canada Revenue Agency's CED guidance that came out in 2013, it does provide for, quote, program-related investments, which basically is their term of referring to social investments, although the feds and the provinces haven't quite coordinated the requirements, which is a bit challenging. What's a program-related investment? It's investment to get a dual return of achieving a charitable purpose, as well as getting a return in place. Examples would be acquisition of shares or making loans over to other businesses. You can do a program-related investment with not only other charities, but with qualified donees. Next slide, please. But here it gets complicated. You not only got to do the rules to be a social investment in Ontario, you got to do the rules to be a program-related investment at the federal level. So you got to have a policy in place. Then you got to make sure if you're doing a PRI with a non-charity that you have co-direction and control, which is a ton of fun. Lots of requirements there for separate topic. Got to make sure there's no private benefit. You got to have an exit plan, and you got to make sure you have adequate books and records. So lots of requirements. If you're going to do impact investing, you got to read this, again, the provincial side, and you got to read the federal side. Next slide, please. And some of the rules at the federal level is, if you're a foundation, you're worried about your disbursement quota, which is obviously an interesting topic these days with the consultation. Your program-related investment, the money's used for program-related investment, won't add to the base to calculate your 3.5, but it doesn't count towards meeting your 3.5, which is a little bit frustrating. And then if your program-related investment, i.e. social investment at provincial level, no longer meets the definition of being a program-related investment, then you've got to either justify it as a regular investment or an investment, or you've got to have an exit plan to get it out. Next slide. And then finally, just some other factors to consider with impact investing. Remember about the not having majority control by public or private foundations, and see the earlier slides on that. Excess business owning rules apply to private foundations. Limited partnership rules can come into play as well. And also under the Charities Accounting Act, if you exceed 20%, then you've got a substantial interest that allows the public guardian trustee to have oversight. All of this to say, income generation, it's possible, but it's complicated, right? It's doable, but you have to know the rules. And so what I've tried to do for you is just give you an idea of sort of a high-level overview of what some of the rules are. Can you do related business? Yes. Can you do unrelated business through a for-profit subsidiary? Yes. Can you be involved in social enterprise? Yes, both within the charity and outside the charity. Can you be involved in impact investing? Yes. But you got to know the rules, because remember, you're reporting to your directors, and of course, the directors are going to be concerned about, what may be issues that they'll have to look at. And the liability side is always a question that the directors and officers look for. So under the Q&A section, that was really one of the questions. What sort of due diligence is required for directors of charities before they embark on income generation through related business or through social impact investing? And I think the answer to that is it's a good idea to work with your legal counsel and your accountant. It's important because you can't, possibly understand all of the rules. So that's number one. Get some professional assistance. Number two, take a look at the pros and cons associated with the opportunity for income generation. charities need to increase their ability to earn income. They just do. It's basic. And hopefully there'll be changes coming in the future years, but at the present time, the rules that are in place are there. So do an evaluation of whether or not the opportunity for income generation is going to be sufficient to justify the extra work. Make sure that you're aware of the risk involved, because as directors, you don't want to expose yourself to unnecessary liability. Rely upon your professionals, and then make sure that you follow through and you do the required homework to both set up the structure and to implement it. If you do that, it's very possible to have an extra source of income beyond the usual donations that you otherwise have. Lynne, I think I'm going to stop at that point because I want to be respectful of the time limitations that we have. And then if there happen to be any more questions at the end of the morning, I'd be happy to take them. But I'll stop my presentation now. Lynne. Thank you. And you're muted, Lynne? You're still muted, Lynne?
There, you can hear me now. Thank you, Terry. That was a lot of information, but really, really helpful and quite clear. So please, everyone, if you have questions, I think we will have time at the end for Terry to take his questions. So now I'm going to introduce you to my partner, Laurie Turner. So Laurie is a corporate commercial lawyer in our Fasken offices in Toronto. She works for not-for-profit and for-profit entities, but particularly those in the healthcare space. And Laurie's going to speak to us about the due diligence that is necessary before accepting a large gift. And this is a subject that I think you'll agree is really important in these politically correct times, in these times where we have so much power in our social media. We want to make sure that when we accept these large gifts, we understand who we are accepting them from. So Laurie, I will turn it over to you now.
Great, thank you very much. So when charity staff becomes aware of a potential forthcoming donation, we know it's natural for them to be excited about that potential donation and to start thinking of all of the charities projects which could greatly benefit from that donation. However, this excitement, it's important that it doesn't interfere with or cloud the judgment in the context of due diligence for gifts. So the question is, why conduct due diligence in the context of gifts and pledges? And obviously, we'll get to this a little bit more in terms of obviously, the larger the gift, or if there's naming rights involved, it will likely increase the scope of the due diligence that's required. But we'll just speak about why due diligence is necessary in the context of gifts and pledges generally right now. So first, so it assists directors in fulfilling their fiduciary obligations or fiduciary duties. So as you know, directors of charities are expected to be involved in the charity's decision-making processes and are also required to handle the charity's property with care and diligence and to protect the charity's property from undue risk of loss. They're also responsible for ensuring that charities operate within the law. And it's for this reason that these directors are often referred to as charitable fiduciaries. Part of discharging these duties is being knowledgeable about gifts that are being accepted by the charity. And this is particularly the case where the charity will publicly associate itself with the donor, such as where naming rights are involved. Due diligence may also assist in the event of future litigation and may reduce the likelihood of unwanted consequences and surprises arising later. So, investing the time and effort to conduct sufficient due diligence at the front end can significantly reduce the chances that the charity will, in the future, for example, need to avail itself of the relationship with the donor in the future. And such a move would be obviously costly for the charity, not only from a financial perspective, of course, but also from a reputational perspective. Due diligence may also identify unwanted sources of funding. So as part of a due diligence process, it's likely that you'll explore the source of the funding And it may be that ostensibly the funding is coming from an individual donor who is the recipient of a family inheritance, but after due diligence is conducted, you may uncover that the source of funding or the original source of the funds as coming from another activity that the charity deems unsavory, whether or not that's a criminal activity or simply an activity that the charity has a policy of not associating itself with. Also, in some circumstances, the motivations behind a donation can be revealed as negative. For example, if there's a criminal intent behind the donation. And finally, due diligence may be required by your organization's policies. So we'll discuss these policies a little later in this presentation, but it might be the case that due diligence generally, or even a defined course of due diligence, is actually mandated by your organization's gift acceptance policies. Next slide, please. So it's important to understand the distinction between a gift agreement and a pledge agreement, particularly for the purposes of properly documenting donations. So the term gift agreement and pledge agreement may be used interchangeably. However, on the one hand, a gift agreement will document a gift having been made by a donor and the terms upon which the gift was made, while on the other hand, a pledge agreement will document a commitment by a donor in the future, to make a gift in the future. It also might be a mix. It might be that the agreement is documenting a current gift and then also a pledge to make a gift in the future. And while the question of enforceability of these agreements is outside the scope of this presentation, a pledge agreement is generally not legally enforceable except in limited circumstances, including where there's consideration flowing between the donor and the charity. So whether that's of a nominal amount paid by the charity to the donor in consideration of the donor's promise to make a gift in the future, such as $1, or on the other end of the spectrum, the granting of naming rights in favor of the donor. Next slide, thanks. So moving now to due diligence and sources of information or sources of due diligence. When your organization is conducting due diligence, the scope of that due diligence will be dependent on numerous factors, and those factors we'll explore a bit later in this presentation. However, due diligence might start close to home or internally within your organization, and various factors might trigger the need to expand the scope of that due diligence beyond local sources, even to international sources. So the first source of information for due diligence that I have listed here is board and committee members. This is a great first source. A great place to start is canvassing your board and committee members for knowledge of past experience with a donor. So it might be that certain of those board or committee members have sat on the board of another charity that's received a donation from this donor in the past. So obviously a good source of intel. The second source of information that's listed there is board members of friendly charities. So it may be warranted to inquire about potential donors with directors of other charities. And I've said friendly here in quotations, as your charity obviously will not want to approach another charity with whom it doesn't have a friendly relationship, and could be tipped off that a donor is looking to make a gift and use that information to solicit the donor. However, in making these sorts of inquiries, it's important to keep in mind confidentiality obligations. So first, prior to canvassing those individuals outside of your organization, whether it be other board or committee members more on a formal basis on behalf of your organization, or even in an informal setting, you will likely want to obtain direction to do so from your board or for executives. Otherwise, you may, either as a director or even just an employee, be breaching your confidentiality obligations to the charity. And second, in terms of confidentiality, it's important to consider whether or not the charity has made any commitment to the donor to keep the potential gift confidential, either in the short term, so for instance, until the terms of the gift are negotiated, or until the gift is publicly announced, or even in the long term, if it's ultimately the intent that the donation will be an anonymous donation. Moving on, another source, obviously, of information, is the internet. Of course, it can be a very helpful tool. However, your searches can be even more effective when you use specific search terms that have proven helpful in identifying potential issues for charities in the past. So if you look online, many organizations and service providers will publish these, great search terms or helpful search terms for charities to use in conducting due diligence. So you may want to look into that. In terms of social media, such as Instagram and LinkedIn, I'd like to keep in mind a couple of things. First, while it's common for individuals to use their full names or their full legal names on platforms such as LinkedIn or Facebook, it's not necessarily as common for full names to be used on other platforms such as Instagram, because only one user can have a certain handle. So people have to come up with other names that might not necessarily reflect their true legal name. So therefore, a search of a social media like Instagram, where it yields no users, may not necessarily mean that there's no account. You'll also want to, in the course of social media, as a tip, look, for example, at the number of common friends or connections with the donor. So from personal experience, if I get a request from somebody on Instagram and we have no mutual friends and they have 3 friends, that's obviously a red flag in terms of whether or not this is a person who, may not be of the best background or have the best intent. Also, as part of your social media due diligence, take your time to look at pictures. We know that pictures can be a great source of revealing poor or damaging past behavior. And also, if possible, look at what that person is supporting, liking, or aligning themselves with through the platform. So are they liking posts of political movements that are inconsistent with the charity's mission, for example? In terms of public searches, these are searches that are often performed by law firms and include, for example, bankruptcy searches. So this search searches all the bankruptcies recorded since the 70s. Obviously, a board of a charity would have egg on their face later if it was determined that they had accepted a donation or a pledge for a gift that from a donor that was bankrupt and obviously never had the intention of fulfilling that gift or the means to fulfill that gift. Another public search that can be really helpful is a litigation search. So these searches can be done across the province, across Canada, or even internationally to determine if the donor is a named plaintiff or, more importantly, often a defendant in litigation. And the cost of these searches will really depend on, in the case of a litigation search, how expansive your search is. So you may search locally, so within the courts of Toronto, you may search provincially, but when you get up to the level of international searches, that's where the cost becomes quite large. And so it would have to be a matter of weighing the risks of not proceeding with international searches in the case of a large gift against the cost. Another source of information are global risk and compliance databases. So we're aware that auditing firms such as PwC offer due diligence services to charities. And these sorts of services may, dependent on the agreed to scope, include a search of global risk and compliance databases. And also criminal record checks. So there's 3 different types of criminal record checks. And pursuant to the Police Record Checks Reform Act, which was made in 2015, the consent of an individual is required in order to perform any of those criminal record checks. So we're going to talk a little bit later about whether or not you obtain the consent of a donor to do due diligence, but in the case of a criminal record check, you would necessarily have to obtain the consent of the donor. And those criminal record checks can be made, requested through the police directly or through many service providers that offer this service online. In terms of resources for due diligence, one of your first queries will be whether or not due diligence will be performed using your internal resources only, such as just your staff within your organization. So whether or not, for example, they'll conduct, just simple web searches, social media searches, that sort of thing, or whether or not you'll also use external resources. So whether or not you'll use professional advisors who have expertise in this area, who are retained for this specific purpose, or maybe a combination of both. And notably, what sort of resources you'll use and whether or not you'll rely solely on internal resources or draw on external resources may be driven by your organization's policies. And we're going to take a look at that in the next few slides. So with respect, again, to considerations for due diligence, a question is whether or not there's a policy at your organization that governs due diligence on donors, such as an acceptance of gift policies, and if not, should there be? And the following considerations are a starting point for drafting such a policy or even making amendments to a policy that's already in force. And a question or a first consideration is what drives the required scope of due diligence, or in terms of what type or what nature of due diligence is required to be performed in what circumstances. So what those factors may include all or some of the following: the amount of the gift or the pledge, the donor type, the donor location, and whether naming rights are attached to the donation. So the next slide. So on this slide, I've just set out an example matrix pertaining to the required level or scope of due diligence. Of course, it's an example only, and the specific scope or nature of the due diligence that your organization will perform will be contingent on various factors, including, the size of your organization. So in this case, I've set out the different levels of due diligence. What specific due diligence activities are required in each level, and what types of donations are deemed to be level 1, level 2, and level 3. So, for example, in a due diligence level 1, it might be applicable where a gift or pledge doesn't exceed a certain amount, where there's no naming rights that are provided to the donor, and where the donor is a repeat donor or is otherwise known or a friend of the charity. Well, on the other end of the spectrum, you might have a due diligence level 3 where gifts or pledges exceed, a certain specified amount of money, when naming rights are provided to the donor such that, you're agreeing by way of a contract to include that donor's name on a building, whether perpetually or for a specified amount of time, or where a specific amount of due diligence is warranted on account of previous due diligence or otherwise required by the board. Next slide. Continuing with considerations for due diligence, a question of what resources are available for the process. And this will likely depend on your organization in terms of the level of resources that are available. So it might be the case if you're a larger organization that you have a larger spend available for due diligence, and you may be able to retain external counsel and a broader set of circumstances, or it might be the case that you're a small organization that will be required to perform all of the sources internally and actually don't have the ability to rely on external service providers. Another consideration is what resources are required to be used for the process. And again, this might be set out in your policy. So question whether or not your policy mandates any specific resources to be utilized. For example, the use of a third-party service provider who's experienced in this regard. Another consideration is how will due diligence findings be presented and to whom? It's unlikely the case that a board, for example, is going to want to receive a 50-page report on a donor. So consider how those due diligence findings are distilled into a product that's going to be helpful for your board in making a determination as to whether or not to accept a gift or enter into a pledge agreement. Another query is whether or not any due diligence findings necessitate that the matter be escalated. So it might be the case that when you're providing instructions to either your internal staff or your external service provider, you might indicate that, you know, as soon as you, or if you find that the donor is associated with X industry, stop the due diligence and come back to us, because it might be the case, for example, that your charity has a policy that you won't associate yourself or take donations from specific industries. And another consideration is whether or not you will obtain donor consent to due diligence. And I touched on this a little bit earlier. So this was a question that came up recently from a client. And as part of that, we canvassed organizations to determine whether or not donor consent to due diligence was generally obtained, and found that it wasn't standard to obtain the consent of the donor for due diligence. Again, there might be exceptions to this. So for example, if you're at certain sort of searches like police record searches require the consent of the individual, or it might be the case that you require specific information from the individual to do types of searches such as search under the Personal Property Security Act. So you need their date of birth, for example. So that will just be dependent on what type of searches you're going to do, but generally we hear that the standard is not to obtain donor consent. So moving now to gift agreements and documentation of gifts. Once you've completed the the initial due diligence as a method of reducing risk to the charity, you'll also want to keep minimizing the risk to the charity forefront in your mind when drafting any agreements documenting gifts or pledges. And the terms of these agreements will, of course, be subject to negotiation with donors. So I could sit here and say, you need to include this, you need to include this. This is an ideal provision, but of course, it's going to be subject to what the donor is willing to include in the agreement. And also a matter of the charity deciding when to walk away. So, you know, it might be the case that it's just not worth the risk that, you know, you might receive the gift up front, but that the donor isn't kind of willing to stand behind the gift or provide any sort of representations about the source of funding. And you may decide that, you know, before you are even able to paper the gift, that you want to refuse that gift. So within this agreement, you could include representations and warranties from donors as to the matters sought to be confirmed as part of your initial due diligence process. You could also include obligations on the donor to disclose certain events to the charity, such as in the case where any representations or warranties of the donor that are provided in the agreement become untrue or inaccurate in the future. And then another large issue that comes up with gift agreements is what to do if a charity has already received a gift and then wants to return the gift later. So generally speaking, a charity can't return a gift once it's accepted because it's required to use that gift in carrying out its charitable purposes. Accordingly, you might want to include a provision in a gift agreement that upon the occurrence of certain events, your organization can gift the property or the donation to another qualified donee who is willing to accept the donation. So for example, it may be that your health charity, after accepting a gift, becomes aware that the funds stemmed indirectly from the tobacco company, and your organization has a strict rule that you won't accept gifts from tobacco companies. However, it might be that other charities don't take the same view or would gladly accept these funds. So in that case, provided that it's in your gift agreement, you could gift those funds to another qualified donee. I will say though, however, in any event, if you're in a situation where you want to return a gift, it's very important that you get legal advice because this can be a really sticky situation. So with respect to pledge agreements, as I mentioned earlier, pledge agreements document a commitment by a donor to make a gift to a charity at a future date. And it's only enforceable where certain conditions are met. So it's important to clearly document the terms of the arrangement, particularly where naming rights are involved. And if policies are referenced within the pledge agreement, so for example, if you say that the terms of such policies must be complied with at all times during the term of the agreement, then you'll need to ensure that the terms of these policies in the agreement are consistent. And this might seem obvious, but it's often the case that you have on one hand people within your organization developing policy, and on the other hand, you might have your legal counsel drafting pledge agreements. So just make sure that you have those internal discussions to make sure everything is consistent. So where naming rights are included, and this is obviously the case generally where a large gift or pledge is made, this will typically increase the level of due diligence that's required by the charity. You'll need to clearly define within that agreement at what time the naming rights are triggered. So are the naming rights triggered on the charity's receipt of 25% of the pledge or 50% of the pledge? Obviously, be careful with granting those naming rights before any amount of the funding is received, or even if a small amount of funding is received. The agreement will also need to clearly define in what circumstances or instances the naming rights can be revoked. So for example, where the donor engages in specified conduct, where the donor fails to advance funds in accordance with the agreement. So we're recently involved in a case where a donor hadn't engaged in any sort of untoward conduct or anything. It was just the case that they had failed to realize on many years of pledges. And so the agreement didn't specifically contemplate a situation of this nature and what the charity's rights were. So just making sure that all of these terms are clearly defined in the event that there's any issue with the donor. And again, this will all be dependent on what can be negotiated. But with an eager donor, perhaps you could make the donor responsible for costs related to debranding if it becomes necessary, for instance, due to the donor's acts. It is important, though, to also note that even if due diligence is done, you can't protect, obviously, against all risks. And as is clear from recent changes in views of political leaders, for example, in respect of whom universities are named, a donor may not do or fail to do anything that leads to the need for disassociation. And that disassociation may just merely stem from a change in perception. So again, just in drafting those agreements, make really sure that there's an exit plan and when those exit plans or when those exits can be triggered. Next slide, please. So again, in terms of where naming rights are included, the agreement will need to clearly define how long the naming rights will continue, whether or not the naming right will continue perpetually. And I'm sure your legal counsel will advise that that comes with risks in itself, but also if not perpetual, how long? So whether it be 50 years, 25 years, et cetera. And if the naming right isn't perpetual, does the donor or the donor's estate have a right of first refusal with respect to the name after the date on which the original right expires? If yes, subject to what conditions? So that expiry of the initial right will serve as a good time to conduct fresh due diligence. And it's important that any such right of first refusal is subject to the condition that the charity is satisfied with the results of the due diligence that's conducted at that time period. And another consideration is just considering the cost to the charity of having to remove the name. So in addition to obviously the charity having the right to remove a name from a building or another part of its institution, just in terms of considering practically what that will mean for the organization from a financial standpoint, but also a reputational standpoint as well. So for instance, if a university has named one of its departments after a donor and it becomes widely known as that, and part of the university's recognition is dependent on that name, then there's obviously going to be a reputational and therefore probably financial cost to the charity of removing that name. So finally, just wrapping up with some other matters, it's important to always keep detailed documentation of due diligence that has been conducted. Again, that can help support directors in confirming that they've discharged their fiduciary duties, the results of due diligence, so you can turn back to that at a later date if need be, and also documenting decision-making with respect to the acceptance or rejection of a gift or pledge. Also, ensure that you update policies on a routine basis to reflect lessons learned. So for example, it might be the case that as part of due diligence processes, you find that specific types of due diligence or resources for due diligence are really effective. You might want to update your policy to reflect that. Or you also might want to reflect your policy to update decisions that have been made in the past. So it might be the case that the board has made a strong decision to reject a gift in a certain circumstance, and you might want to reflect that in your policy. And then finally, we'll end on an important note of implementing ongoing monitoring. So a donation from a celebrity or hero today can be a donation from a villain tomorrow. And this underscores the importance of continued due diligence and monitoring. Due diligence shouldn't stop once the donation is received. And while due diligence that's performed in advance of the receipt of a donation is, for the reasons that we've discussed, critical, its value continues throughout the life of the donation. And it's important, therefore, to see due diligence as a continuous process. Charities are busy and justifiably so, often focused on securing the next gift or donor. However, it's really important to ensure that you implement monitoring of donors on a regular basis, whether this is twice yearly or otherwise, really as much as your organization can support. Monitoring can help ensure that your organization will be in a position to take a proactive rather than reactive response to new information. And it might also provide your organization with an opportunity and time to assess your options. And that time will quickly fade as the information becomes more widely known and publicly available. Thank you very much. So I'll take any questions that have come up. Okay, so I don't see any questions popping up on my end right now, but I will return to these maybe a bit later. If anybody has any questions, they can reach out to me by email. Thank you.
Well, thank you very much, Laurie. We tried to make these seminars practical, and I think that was incredibly practical and helpful seminar. So thank you very much for your talk. All right, we also tried to make our topics very timely, and I hope you'll have seen that with all of our topics, but I have to say, we really got the next one kind of perfect. We had to come up with our list of topics for this seminar during the summer. We had an inkling that the new Not-for-Profit Corporations Act in Ontario might be coming into effect this fall. I'm happy to say we had no sooner got our invitation out for this seminar than the government obliged us and told us that that act would come into effect next month. And, you know, I'm sure many of you were at prior seminars held by Terry's firm or our firm about what we call the new Ontario Not-for-Profit Corporations Act 11, 12, 10 years ago. We even did some of these seminars 8 years ago, and then we thought, okay, that's it. We can't do these anymore until we know that this statute is actually going to come into effect. And happily it is. So I'm going to turn the microphone over at this point to Theresa Mann, who is a partner at Carter's. She practices not-for-profit and charities law. She has been recognized as an expert in these areas by a number of leading organizations that rank lawyers, including Lexpert, Best Lawyers in Canada, and Chambers and Partners. So Theresa, please tell us what we need to know right now about the new Ontario Not-for-Profit Corporations Act.
Thank you so much. Absolutely. This is just very, very timing. ONC is finally here after 11 years. So in the next 30 minutes or so, 25, I won't take 11 years to finish my PowerPoint, to walk you quickly through what it means to Ontario corporations, what we need to do to transition and comply with the new rules, and just walk you through a few of the key elements, interesting rules, unique rules in the new Anka. So next slide, please. So a bit of an overview, like what I said. First of all, we'll walk through the status, some practical steps to transition, and some rules. And a bit of a caveat. This presentation is not about interesting share capital social clubs under part 2 of the OCA. These are like yacht clubs, some golf clubs, they have shares, but they file as nonprofits under the Income Tax Act. For them, they have 5 years to continue, and then they have a choice whether to go under the new Anka, to move into the new Business Corporations Act, or become a co-op. So today is not for those entities. I want to focus the regular Part 3, lattice pattern, membership-based, non-share capital, typical Ontario corporations. And also another caveat is Special Act corporations. So to incorporate a corporation, you can incorporate under the OCA Part 3, like what I just said. It is also possible to go to the Ontario legislature and ask the politicians to pass a special legislation to incorporate a particular corporation. There are many examples out there. Whether the OCA/Anka applies to special corporations depends on what the provisions in the Special Act says. Some Special Act actually says OCA/Anka does not apply, and therefore you don't need to worry about Anka. Some will say whatever that's in OCA and Anka apply unless they are trumped by the Special Act. Some may say certain provisions in OCA/Anka would apply to us. So it depends on what the Special Act actually says. So if any of you listening today in relation to special corporations, you need to read the Act first and then look at the Anka rules. Next, please. Yes, as I said, finally, Anka is here. And it is the beginning of a new era. Why? Because the rules under Anka is so different. And another wonderful thing is under the old OCA, about to go out in about a month, everything is paper filing. You have to sign wet signatures, single-sided, you need 2 copies, go to the ministry. I cannot have color photocopy of signatures. They must insist on 2 copies. They want single-sided. I have clients who does not listen to me and give me double-sided print. I have to go back and sign them again. So under Anka, everything will be electronic filing. Next, please. A bit of a acronym. So the current act, I will call it OCA. It is about to go away. The new act, Not-for-Profit Corporations Act, as I've said a number of times, I'll call it Anka. Some people call it ONCA. Depends on the mood of me. On a particular slide, I may use either term interchangeably. I've also provided you with a link to the ministry's website for any update. So next slide, please. This is a little bit of a box of a timeline when I have nothing else to do, tracking the development of Anka all the way from 2010, when it was first received royal accent, not including the consultation, the drafting prior to the royal accent. And now finally, exactly 11 years, less a few days later, it will be proclaimed. Next, please. So the next few slides, I want to spend a few minutes on what does it mean to Ontario corporations. So next, please. What we need to understand is as soon as Anka is proclaimed on October the 19th, next month, it would apply to all Part 3 OCA corporations automatically. There's nothing that you need to do. They apply to you automatically. And therefore, if you do not do anything, you just let it pass on October the 19th, no celebrations, no wine, no bubbles, no nothing, then the corporations will not be dissolved. You will continue to live. after that day, not a problem at all. However, you need to understand anything that is in the LP lattice patent or SLP, supplementary lattice patent, bylaws and special resolutions will continue to govern the corporation for 3 years, even if any of those provisions are inconsistent with Anka. However, at the end of the 3-year period, anything that is not consistent will be deemed to have complied with Anka. So it would result in uncertainty because there may be, your bylaw, you may section 2, section 3, sub 5, sub 1, the last sentence doesn't comply, section 10, sub 2, the middle phrase doesn't comply. And then at the end of 3 years, they will be deemed to comply. Then the question is, what would those be deemed to? I have no idea because you need to look at what your bylaw says, what Anka says. It will become extremely, extremely confusing. Next, please. And also, under Anka, the incorporation documents will be different. Right now, under OCA, I talked about lattice patent LP, supplementary lattice patent SLP. Those are your governing documents. But right now, to incorporate under Anka, under OCA, your birth certificate is your lattice patent LP. In the past, to amend anything in the LP, you need to apply for supplementary lattice patent SLP. Under Anka, the documents are going to be called different. They have a modernized system of your DNA documents. There's no longer any LPs or SLPs. There will be articles of incorporation if you want to incorporate a new entity under Anka, or if you want to amend anything in the articles of incorporation, then you adopt articles of amendment. So the terms are different, the forms are different, the documents are different. And therefore, when Anka comes, there's certain information that would be required to be set up in articles under the new Anka system. And that consists of number of directors, 15, minimum or maximum range, how many classes of members that you have. You have a voting class, 2 classes, non-voting, senior members, 2 student members. You need to name how many classes in the articles and which class are voting and non-voting. If you want to have a delegate voting system, those will need to be settled in the articles. And also how the net asset of the corporation upon dissolution will be distributed will need to be set up in the articles. Now, right now under OCA, number of directors, membership classes, voting rights, and delegates, that means numbers 1, 2, 3, 4 on my slide, would currently be set out in your bylaw. So when Anka comes, so that means these 4 things would have been, placed in the wrong document in your bylaw as opposed to the articles. As opposed to number 5, the dissolution clause, older corporations would often have that in the bylaw. More recent corporations, that would be in your LP or SLPs. So if you do not do anything after Anka comes, so these things would have been, misplaced in the wrong document. So Anka also says, if you have these things in your bylaw, if you do not move them into the proper articles of amendment after Anka comes, that's okay. That's okay. So they would not become invalid, of course, as long as they comply with Anka. Next slide, please. And because of the uncertainty of contradictory, inconsistent provisions in your current document being deemed to comply and not knowing what they'll be deemed to, the better thing is to opt into doing an optional transition process. That means within 3 years of proclamation, after October the 19th of this year, in the next 3 years, while your current documents would trump whatever rules that is in Anka, you quickly adopt a Anka and compliance bylaw to make sure that everything complies. You adopt articles of amendment and move the inconsistent things, like the number of directors, number of classes of members, membership voting rights, move them all into correct document. Adopt all of those, then you will comply with Anka and do that within the 3 years, then you would avoid the problematic, confusing deeming process. Next slide, please. And this table kind of like set out the various types of documents because I'm more of a visual person. On the far left-hand corner, my husband said that I cannot tell left to right. So if I say this is right, this is left, forgive me. So on the left-hand side of the slide, I have LPs and SLPs on one row, and then bylaws and special resolution in the second row. So, and then the next column, it says what if you, during the first 3 years after proclamation, these documents will continue to apply in the LPs and SLPs and also the bylaw. But note that your bylaw may not address everything, may not address all of the rules in Anka. So that means if there's any new rules in Anka, because Anka is very modern legislation, it's much more complicated. It has many, many more rules than the current OCA. If there's anything in Anka that is not addressed in your current bylaw, so those rules will apply to the corporation right away, even during the first 3-year period. So just take a note of that. And then after 3 years, and then the next column, I've talked about that anything inconsistent will be deemed to have complied with Anka, and that's where the confusing thing would occur. So the far right-hand side on your slide, that's the right-hand side. Right-hand side of the slide, that means during the 3-year period, do the optional transition process by adopting articles of amendment to ensure compliance and adopt bylaw to comply with Anka. Next slide, please. So what do I do? So now that you said that it's good and prudent to do the optional transition step, I hear you. So what do I do? How do I do that? Next, please. In the next 3 slides, I set out a few steps to do in order to get ready and to complete the Anka transition process. And I give it an acronym, so CRS-CPA, collect, review, study, compare, prepare, and approve. So I'll go through each one of them, with you. And then after this set of 3 slides, the last set of slides, there will just be some highlights of rules in Anka, which I would likely not go through in detail, but I would pick up a few highlights. So first of all, what do you do? Number 1, collect your documents and ensure that you are indeed a OCA corporation. 10 years ago, when the federal legislation, the federal new CNCA came, they have 3 years to transition from the OCCA to the new CNCA. So I have clients coming to me, what do I do to move into the CNCA? I have new bylaws prepared and drafted. Can you review the bylaw for me? So I did a quick check. It's not even a federal corporation. It's Ontario. So they are 11 years too early. So all of the work that they have done on preparing a federal bylaw, they can shelve it, and now they can revive it and see, how they can fix it to make it comply with the Ontario rules. So first of all, you need to make sure that you are indeed a OCA corporation. You need to find out whether you are a special act corporation, whether you are a Part 2 social club, share capital corporation. You need to find out who you are. Find your DNA, your birth certificate. So you need to collect all your LPs. And if your LPs have been amended, find your SLPs. And those you can do quick searches through the Ontario government's database. You have to pay some money to get copies. It will take quite a number of weeks to get it. It's taking longer and longer. It used to be 3-4 days. Recently, I think it took up to 5-6 weeks to get copies. I think it's because everybody wants to pool the LPs and SLPs to find out what it currently says. You need to collect all your bylaws, including bylaw amendments. Bylaw amendments could be in your amending bylaw if they've been adopted by way of amending bylaw. I have clients who in the past adopt bylaw amendments by moving motions at membership meeting, recording the amendment in the minutes, and not extracting them out to consolidate into the bylaw. So for those clients, I had the wonderful pleasure to spend hours to plow through past membership meeting minutes to extract how they have amended the bylaws over the years in order to have a current set of bylaw provisions that currently applies. And then you should also collect any governance-related document. There may be org charts, policies, manuals, because there are many times my client came to me and then I asked them, well, this is what your bylaw says. And then they say, oh, really? We didn't even know, what does this say? We never looked at it. This is not how we do things. So I asked them then, how do you do things? And then they tell me that we, instead of do this, we do that. And then I said, well, is there a policy? Do you have a procedure set up? No, everything's in my head. So you need to, after you've collected everything, go through them, pull out your governance-related policies and manuals, and see whether they actually reflect how you operate. So this is the second step, review. Look at them. Do they still apply to you? Are they outdated? Have you been following the same document over the years? Have you been not following the same documents over the years? Look at them, see how they relate to your current governing process. Next slide, please. And then the next step is to know the Anka rules, because we said we need to comply with Anka. So we need to know what Anka is about in order to be able to comply. It's not a long legislation. It's only like 200 some sections. You can easily go through them in a few months, not a problem at all. But there are many resources out there that you can get you up to speed. Something to make sure that you understand is Anka is a framework. There are rules in the legislation. There are rules in the regulations. The still to come is like not correct. Regulations has already been posted and passed. Still to come means they will come on proclamation day. And then you will set out provisions in the articles and bylaw. Those will be trumped by the rules in the act and the regulation. And then there are also 3 types of rules in Anka. Some are mandatory that you must comply. Some are default that you can opt out or opt in. Some are alternate that you can adopt if you want to. And if you want to adopt, sometimes Anka may say you would have to adopt it by setting that out in the articles, or you can adopt those by setting it out in the bylaws. It depends on what rules you want to, alternate rules that you want to opt in. Next slide, please. And then after understanding some of the key rules in Anka, you compare how you operate and what Anka says. If there's anything inconsistent, if it is something mandatory under Anka, then you have no choice. You have to fix or adjust your process to comply with Anka. If the inconsistency is something that Anka gives you a choice to opt out, then you can decide whether you want to opt out or whether you want to adjust your process to opt in into the Anka rules. And then Anka, sometimes it gives you some options. Then you can decide whether you want to adopt those other options. So there's a comparison process that you should discuss with legal counsel. And then the last thing is to prepare articles of amendment and also Anka compliance bylaw. So in terms of bylaw, normally there are 2 processes. I usually recommend start with a fresh Anka compliant bylaw base. Do that because it'll be just simpler, easier, much cleaner for everybody. It is possible to go into your current bylaw and fix it to comply with Anka, but that process will likely be much more complicated because the rules in OCA and Anka are so different. There are many rules in Anka that are new, which your current bylaw would never even mention. So probably going with a fresh Anka compliant base would likely be a bit better. Then the last step would be to approve the documents. You need special resolutions to approve the articles. Your bylaw, which depends on what your current bylaw says in order to adopt. And then if you're a registered charity, you also need to file it with the CRA. The adopted articles will need to be filed with the ministry, and then they'll issue you certificate of amendment. Next slide, please. So The next set of slides, I'll quickly walk through some of the key rules in Anka. So I try to set it out in easy to understand table format, but it's not detailed, but I do want to flag them, some of them for you, and then I won't go through each one. Next one. So to incorporate under Anka, we only need one incorporator as opposed to 3 right now. They'll issue a certificate of incorporation. There's no more LPs or SLPs. The documents to use is articles of incorporation, articles of amendment. We talked about that. Bylaws continued not required to be filed, which is the same as the current OCA. If a corporation was incorporated brand new under Anka, and if it does not adopt a bylaw, then within 60 days, the default bylaw will automatically apply to the corporation. And then there are reasons behind it, so I don't want to spend time today because my focus today is on transitioning of current OCA into the new Anka. Next slide, please. Some concept to understand. All corporations in the Anka are divided into public benefit corporations and non-public benefit corporations. So PBCs and non-PBCs. PBCs consist of 2 types of entities: charitable organizations. So if you look at your objects, whether the objects are charitable objects, then if it's charitable objects under the 4 charitable heads, advancement of religion, advancement of education, relief of poverty, or anything else that are charitable, that's called a charitable corporation. Whether it is a registered charity by CRA under the Income Tax Act is not the criteria to look at. The determination is what your objects are in your birth certificate. And then if the objects are not exclusively charitable, then, but if the corporation received more than $10,000 of funding from public sources, which I will quickly talk about, then for that year, that corporation will become a PBC. But in the following year, if it's below the $10,000 threshold or another amount prescribed in the regulations, then will become a non-PBC. So then all other corporations under Anka that do not meet the PBC definition will become non-PBCs. Next slide. Public sources, so this slide talked about what public sources means, and then the rules differ whether the corporation is a PBC or a non-PBC. So it's on the slide, I don't want to go through it in detail. Next slide, please. If a corporation is a PBC, there are consequences on its governance structure. There are consequences on the audit process. There are consequences on where the net asset will go on dissolution. A PBC cannot have more than 1/3 of the directors to be employees of the corporation or its affiliates. If a corporation wants to dispense with an audit, it wants to go into have a review engagement or just compilation, the threshold is higher for PBCs than non-PBCs. And then there are special rules on where the net asset will go. So it's on the slide, I don't want to go through in detail. Next slide, please. And then on the audit rules and audit exemption rules. So next slide. So this slide sets out the threshold, the cutoff level for PBCs if you want to go with review engagement or simple compilation. And the next slide is for non-PBC. So the numbers are there. I'm not a number person, I'm not an accountant. I'll leave it with you to study tonight. When you have nothing else to do, cannot sleep tonight, it makes wonderful sleeping, reading for you tonight. Next slide, please. There are also rules, special rules in Anka about directors. I have summarized some of the key rules in the next 3 slides. For example, now you will be able to provide a maximum and minimum range of directors in your articles, which you cannot do right now under your current bylaws. Directors must be elected at AGMs. You will continue to be able to have ex officio directors if you want to. Examples of ex officio directors would be, for example, hospital foundation. Foundation bylaw may say the CEO of the hospital will automatically sit on the foundation board. So as the CEO changes from time to time, that person would automatically sit on the foundation board. So that mechanism and that position is called an ex officio directors. There's also a new rule that in Anka that allows directors to appoint up to 1/3 of the directors elected at AGM to the board without going through election by the members at AGM. The rule is a little complicated. It may or may not be suitable for everybody, so I don't want to spend a lot of time explaining it because there's a similar rule in the federal CNCA. A client asked me a question, it took me half an hour to explain it. So I don't want to spend half an hour to explain this rule, which may not apply to you. Next slide, please. There are also rules on the director terms. One term, maximum length is 4 years. So you can, your bylaw, you can say 1 year, 2 years, 3 years, 4 years, but your bylaw cannot say one term is 5 years or 7 years or lifetime is not permitted. However, there's no limit on allowing directors to be kept re-elected to the board. So there's no limit on how many terms a director can serve. Next slide, please. And then the Anka is a new modern legislation. So the standard of care for directors will now be objective standard of care of a reasonable, prudent person in a comparison situation. So that's good for directors, anyone who sits on the board. Next slide. There are also many rules on membership. The next 3 slides summarizes rules on membership. You can have multiple classes of membership. If you have non-voting classes, I'm very pleased to advise that Anka was amended to now finally say non-voting members will truly be non-voting. They will never ever have the right to vote under Anka unless you give them the right to vote under your bylaws. So that's a good thing. Next slide. There are also rules in Anka. If you want to remove a disciplined membership, there must be a fair, reasonable process, given notice, and allow the members to object and to give reasons. Next slide. This slide has a very, very terrible things that membership can do because under Anka, members have a lot of rights, including submitting proposal to nominate directors. They can requisition membership meeting, although that is also in current OCA. They can also go to court to ask for many remedies: dissent and appraisal, derivative action, compliance restraining orders, winding up and liquidating the corporation. So many more scary things that members can do under Anka. Next slide, please. And there are very detailed specific rules about membership meetings. Some of the rules are highlighted on this slide. Next slide. And so the key takeaway is monitor the progress of Anka. It's finally being proclaimed on October the 19th. Set up a committee, engage the board early and prepare early and get legal help to ask any questions that you have. And hopefully you will have a very successful and smooth transition into Anka. Thank you.
Well, thank you so much, Theresa. Again, a lot of information to get to, but some really good slides there that will help you after this session. I don't believe there are any questions in the Q&A for you right now, Theresa. So I think we'll go on to the next seminar. And again, people, if you do have questions, I had thought we would take all the questions in the seminars, but it looks like we'll have a few minutes at the end and we can do them there. So our next topic also is a little timely from an unfortunate reason, really. I expect that most of you are aware that earlier this year, Humber River hospital suffered a large ransomware attack. That is a new hospital in Toronto, brand new hospital, and it was built with a technology backbone and really prides itself on being among the most technologically advanced hospitals in the province, and possibly because it had that distinction, it made itself a real target for ransomware. So in our next topic, we're going to be giving you some tips and advice about how to protect yourself from such circumstances. And we're going to be hearing from two Fasken lawyers. First of all, my partner, Daniel Fabiano. Dan, many of you in our health group would know him because he works very closely with us on privacy information and protection, procurement, and technology. As I say, Dan is a corporate lawyer, so he can often approach these matters in a calm and methodical way. Our next speaker who will join Dan is Daanish Samadmoten. And Daanish is a litigator. And so I think some of the work you do, Daanish, is, thoughtful, but a lot of the work Daanish does is putting out fires because he gets involved in privacy breaches. And of course, as soon as that happens, you need to act right away. And he also goes to court as a litigator on privacy matters. So I'll now turn it over to these two gentlemen to talk to us about this subject to do with ransomware, data security, and privacy law compliance for healthcare charities. Thank you.
Thank you very much, Lynn, and it's a pleasure to be here. For the next few minutes, as Lynn mentioned, we're going to discuss data security and ransomware, but with a focus on privacy breaches and of course, a focus on philanthropic organizations in the health sector. As we know, privacy breaches, particularly cybersecurity incidents, have become commonplace, and this is for several reasons. One is the prevalence of electronic communications and systems. We're just using them more. Another is the increasing sophistication of threat actors. We're also better at detecting incidents that we might have missed in days gone by. And there are more requirements and expectations around organizations having to tell individuals about incidents. And so we're hearing about them more. And maybe just advance to there. That's good. So some privacy commissioners have even gone on record as saying that the mere fact that an organization has experienced a privacy breach doesn't necessarily mean it's at fault. These things happen, as they say. It's become so prevalent. In any event, in our presentation, I'm going to start by orienting us to the current statutory compliance landscape. What do the statutes say? And then Daanish will then speak to the sort of evolving privacy litigation landscape. A lot of my comments may be familiar to many of you, but I think it's important that we start by really understanding what's on the compliance side. So Canada is a patchwork of different privacy laws, and there are three categories or buckets of privacy laws in Canada. And on the right, in the blue bucket, we have the public sector laws at the federal and provincial level. In the middle, we have health sector laws, which exist in most provinces. And then on the left, and frankly, the most far-reaching, the most encompassing of the three are the private sector laws. So we have a law at the federal level, and then there's also a law in Alberta, British Columbia, and Quebec. Now, of course, the common law underpins all of this with certain related torts and other considerations. But these three buckets all have something to say about the security of information. And some of them also say or impose requirements around what must be done in a privacy breach. So a critical question for you and for any client that we work with is which of these laws apply, which is the baseline regime that governs how you might need to protect data and how you might need to respond to a security incident. So let's go to the next slide and drill down a little bit on the public sector side. So the reality is that the public sector laws only apply to public sector entities. And in the health context, we're really just talking about hospitals. And frankly, only the hospitals, not hospital foundations. Public sector laws generally impose high-level data security requirements and do not impose breach notification requirements. Now, some governments have by policy directed that public sector entities may have to take a certain approach when handling a privacy breach, but that's not enshrined in a statute. So other than hospitals, this law is not likely to be particularly relevant to most of you in the audience. And even where it is relevant, it doesn't have anything to say about breach response. Let's go to the next slide. There's a common misunderstanding that health privacy laws always apply the moment you're in a health context or the moment that you have some information that is health information. And that's not true. These laws are quite focused. They apply to healthcare providers and folks that provide services to those healthcare providers. So yes, they would apply to hospitals, they would apply to clinics, they'd apply to other folks that deliver care, but they don't apply just because you're in the health sector. Now, most provinces have a health privacy law, and of course they do impose data security requirements if you are subject to these laws, and many of them do involve breach notification requirements. However, I would argue most health sector charities and nonprofits do not have to concern themselves with this law. Again, they're not providing the healthcare per se. They are perhaps supporting the delivery of healthcare by others. And so this is another regime that I think is relevant for some, but not all of you in the audience, particularly when you're speaking about charitable fundraising and so forth. Let's go to the next slide. So as I mentioned earlier, private sector laws have the broadest reach. They are relevant for a significant majority of health charities and nonprofits. Of course, they capture commercial business, but they can also capture the activities of health charities and nonprofits. How they do that, though, changes depending on which law applies. So if you're in British Columbia or Quebec, if that's where your organization is operating, then you will be subject to the health or to the private sector privacy law, which I've listed here on the slide, in both of those provinces. They apply to all activities within that province. If you're in Alberta, there is an Alberta private sector law, but it doesn't necessarily apply to every nonprofit or charity in the same way. And it's a bit complicated, and I don't want to spend time working through when you're in or out of scope of the Alberta law. Suffice it to say, it will capture many nonprofits, but not all. And then the final piece is really the federal law, which applies in every other jurisdiction except the ones listed, which would include Ontario. And that law is the Personal Information Protection Electronic Documents Act. We call it PIPEDA, but it only applies to nonprofits and charities where they're engaged in commercial activity. And so it's not going to apply if you're a charitable organization. You do not have to concern yourself with PIPEDA for every aspect of your operation. You only need to concern yourself where there is an activity that has a commercial character. Let's go to the next slide and talk just briefly about what does that even mean. And again, it's relevant when you're outside of BC and Quebec because those statutes will always apply. It doesn't matter if you're a charity, you're caught, and to some degree, Alberta is the same. But whether a nonprofit is engaged in commercial activity really depends on the context, and you have to look at the particular activity in question and make a judgment call. And there is some bright lines. So if it's a transaction that is of a commercial character, so for example, you're selling or even buying a fundraising list, or you're selling merchandise, those are things that can be seen to have a commercial character. Now, I've seen some conflicting guidance on this point. I have seen some guidance that says, look, if you're a charity and you're simply selling tickets to an event where the purpose of the event is charitable fundraising, I mean, the proceeds of the sale of the tickets will go to pay for the cost of the event, and then the charity will keep the rest. I have seen some commentary that suggests, well, that's not really commercial activity, that's charitable fundraising. But in any event, there is some concern, and if you're not a charity, you're a nonprofit that's not a charity, when you're selling things, you will want to be attuned to the possibility that you're now in the territory of engaging in commercial activity, which means you're caught by PIPEDA. But as it says here at the bottom of the slide, simply accepting donations or providing free services or sending out newsletters, that's not really the definition of commercial activity. There is some ambiguity here, as I hope you've gleaned. And so it is advisable that charities and nonprofits if you can, generally treat yourself as being subject to PIPEDA unless you get specific legal advice that says, okay, well, that particular activity is not caught by PIPEDA because it's not commercial activity. It's a safer bet to say, look, just comply with PIPEDA unless you've got specific comfort otherwise. So let's go to the next slide, briefly touch on, all right, fine, you're subject to these laws. What do they say? Well, they all speak, all buckets, all three of the buckets do speak to the general notion of safeguarding personal information in a manner that's appropriate to its sensitivity. The idea being that the more sensitive it is, the more rigorous safeguards you would apply to it. And some privacy laws go beyond that, and they say, look, if you have a privacy breach, if that information is hacked or your personnel inadvertently disclose it, send an email to the wrong person, you may be subject to a breach notice and reporting regime. And those regimes only arise in two statutes, which is to say PIPEDA. So if you're in Ontario as a nonprofit, you'd be concerned about PIPEDA's regime. And also if you have operations in Alberta, Alberta has its own regime, which is quite similar. The other jurisdictions don't at this time. I should note that Quebec is well on its way to bringing into force significant modernization of its private sector privacy law. That law does have a breach reporting regime. The good news, and I won't get into detail, it's not in force. It is possible that it may be adjusted given what else is going on in Canada. The good news is it is very similar to the PIPEDA and the Alberta regime. And so when it comes into force, you can stay tuned and we'll discuss it again. Let's go to the next slide and let's just unpack a little bit about, okay, if you're subject to these statutes that have a breach reporting regime, what does that mean? Well, PIPEDA says, look, if you've got a breach of a security safeguard and there's personal information at issue, and so for example, you've lost the personal information or someone has accessed it without authorization or it's been disclosed without authorization. So that would be a breach of security safeguards. And if it's reasonable in the circumstances to believe that the breach creates a real risk of significant harm, not my phrase, it's the phrase in the statute, but a real risk of significant harm to the individual, then the mandatory notice and reporting obligations have been triggered. And so inevitably when there is a breach, the first thing that you or your privacy officer or your legal counsel needs to sit down and do is determine, is this a breach of safeguards of personal information that was under our control? And is it reasonable to expect that there's a real risk of significant harm to the individual? Now, significant harm, we're talking about humiliation, damaged reputation or relationships, identity theft, so that someone could be defrauded. Those are all examples of significant harm. And whether there's a real risk itself involves some analysis. And you'd have to look at the sensitivity of the information and how likely is it that it'll be misused. And there's a number of factors that commissioner guidance suggests that you consider. But the moment you're satisfied that yes, this is relevant, you're into the mandatory notice and reporting obligation. Alberta's regime is not worded in exactly the same way, but it's similar. Next slide. So if you're subject to PIPEDA, as many organizations in Ontario are, then you would need to be concerned about a number of things. First off, even if you don't trip that trigger on the previous slide, right? You decide that it is a trivial breach, you still need to keep a log that summarizes all of your breaches. Now, you're going to keep the log in a way that doesn't, itself involve a bunch of personal information. You'll strip that out, but you will log what has happened, and this is required by PIPEDA. The idea being that the federal commissioner could go in and look back and make sure that you, in an investigation, that you actually reported to individuals breaches that you were supposed to report. So it's a way for the regulator to ostensibly validate that you were doing what you were supposed to do under PIPEDA. It is notable, though, that the commissioner has indicated they'll only go back 2 years. So you can destroy records for breaches that are more than 2 years ago. But setting aside that, if it is reasonable to believe that there's the real risk of significant harm, so if we did trigger the mandatory requirement, then as soon as feasible, 2 things have to happen. First, a report of the breach needs to go to the federal commissioner, and PIPEDA actually says what that report has to say, what needs to be covered. And then second, you have to notify affected individuals of the breach. And again, PIPEDA says what that notice needs to say. Both of these things, the report and the notice, clearly require careful drafting. Good idea to get legal counsel on what it is you're saying, given the fact, and Daanish will speak more of this, given the fact that you could be facing litigation, class action litigation even, due to the breach. And so what you say to the quote unquote victims or to the regulator needs to be clearly vetted. There's also some requirements on how you give the notice, and I won't get into them, whether you give them directly to the individual or whether you post them, on your website. I mean, there's a bit of a careful analysis that goes into how you might tell individuals, but there is the option for doing so indirectly. Next slide. Just to quickly summarize Alberta, for those of you who may have operations in Alberta, very, very similar. The key difference, though, is in Alberta, the statute says you report the breach to the commissioner, and the commissioner can then say, all right, I've looked at this. You now need to notify affected individuals. Most of the time, for our clients, the breach is subject to both of these statutes, both PIPEDA and Alberta. And so you've already likely notified the individuals at the same time as you're notifying the commissioner. But this is just one of the nuances that Alberta has. It's a sort of a two-stage process if you really wanted to be strict to the letter of the statute. So let's go over to the next slide. Canada's privacy patchwork can be a headache to navigate. I mean, even the last several slides, I mean, it's a bit of a maze as to where you head and which law applies. And there are many cases where a nonprofit or a charity may look at a breach and say, actually, I'm not subject to any of these statutes. I'm not a healthcare provider. I'm not a public sector entity, and I'm not engaged in commercial activity. And so therefore, none of this stuff applies to me. And so I can kind of do what I want. And this may be helpful. It actually may be helpful to not have a statute looking over your shoulder saying, you got to do X, Y, and Z, and here's how quickly, and here's what you have to say. Great. But that doesn't mean you necessarily have a free pass or complete latitude. As Daanish's remarks, I think, will underscore, there's a number of general principles that any nonprofit or charity should consider, regardless of whether the statutes apply. In fact, even if they don't apply. And the first is take guidance from those laws. Be informed by what they say, even if they don't apply. So if there is a real risk of significant harm to the individual, you should be notifying the individual, very likely, even if you're not subject to a statute that says otherwise. And when you are notifying the individual, the purpose of notifying them is to enable them to help themselves. And so be cognizant of sharing the right sort of information with the individual so that they can self-help. One of the worst things we see is where the notice goes out to individuals and it does one of two things. It either speaks about preliminary facts, which then cause individuals to become far more concerned than they need to be, or the reverse. It doesn't give them enough information, and now they're worried about what harms that could befall them. So be informed by these privacy requirements, even if they don't apply to you. The next is that privacy laws are changing, and I alluded to this earlier. New obligations will arise, and it's important to stay tuned. There's a modernization of privacy laws underway at the federal level and at the provincial level, and the modernization is at different stages. Quebec, very far ahead. They're likely to announce that their statute is finalized momentarily if it has not been done, an hour ago or yesterday. Although it is not in force yet, merely that it's finalized. The next is federal reform. PIPEDA was the subject of some reform in fits and starts. The election will have delayed that, but that effort will be renewed post-election, no question. And other jurisdictions are also sending signals. BC has sent signals that it's modernizing. And Ontario is moving towards enacting its own new privacy law that I expect will apply to nonprofit organizations in a similar way as BC and Alberta. And then the final point I'll make is that the litigation risk applies regardless of whether these statutes apply. It doesn't matter if a statute talks about breach notice, you could still face litigation for failing to properly inform individuals or failing to properly respond to a breach in a way that mitigates the harm to individuals. So enough with that. I'm going to turn it over to Daanish to get into some of the evolving litigation landscape and related comments.
Thanks, Daniel. So Daniel touched on a lot there. I'm going to touch on a lot. So if you do have questions, feel free to put them in the chat, and we'll try to answer them either at the end of this part or at the end of the session overall. Just this slide has just a few examples of different incidents and some headlines in the newspapers. You'll have heard Lynne mention the Humber River Hospital ransomware attack. That was a big one that was in the news a couple months ago. And so for example, for that one, it was pretty serious. They lost access to their computer system. So they had essentially lost services. They could still do their emergency services, but they lost a lot of services and, couldn't go back and look at patient records from 5 years ago. So it's hard to make medical decisions when you don't have access to medical records. And I just listed a few other healthcare sector incidents here for examples. I've acted personally for multiple healthcare charities that have had incidents. And so it's affecting both the healthcare public sector, but also the healthcare charitable sector. And just for a point of reference, you'll see in the bottom right of the slide, it says more than 28 million Canadians impacted by a data breach in the past 12 months. This is according to the Office of the Privacy Commissioner of Canada, which is the federal commissioner that Daniel talked about. So 28 million Canadians is basically everyone over 18. So in the entire country. So that's, that was only in a 12-month period after the law first came into effect, the PIPEDA law that Daniel mentioned. So this type of stuff is happening all the time. And so one of the things I'll talk about, and that Daniel touched on a little, is how you respond is really important. Because as Daniel said, it's very likely to happen to you at some point. And the big differential is going to be how you actually treat it. So next slide, please. So as Daniel said, I'll touch a little bit about litigation. This slide, I don't obviously expect you to read any of that or even be able to see it. But this is just a chart we keep of privacy litigation at the firm, not only our files, but all privacy litigation that we're aware of. And this is probably 3 years out of date now because I haven't had the screenshot of it. So it's much longer than this. I couldn't fit it all on one slide. So there's a lot of privacy litigation that is occurring in Canada. And as Daniel mentioned, some of it's even class action litigation, with some of which are claiming essentially $20,000 per person affected. And that's based on a case from about 10 years ago that one of the partners at our firm argued in respect of a privacy breach. And the Court of Appeal of Ontario determined that even if you are not harmed by a privacy breach in the sense of like your identity is stolen or you had to spend some money, just the fact of the harm of a breach, just the fact that it occurred can lead to up to $20,000 of damages. So some of these cases on this chart are claiming essentially $20,000 for every person affected in an incident. Next slide, please. A new sort of evolving area of litigation is director and officer claims as well. This is happening more in the States and has happened in the wake of many incidents. You might see Brian Mulrooney on the slide if you look closely. It's in a Where's Waldo type of situation. So this has happened to TJ Maxx, Heartland, Target, Wyndham Hotels, Home Depot, et cetera, against their directors and officers in the wake of incidents, claiming that as a director and officer, they were negligent in their duty in ensuring the company was properly prepared for incidents like this. And we're starting to see some of these cases in Canada. And also some directors and officers have just been ousted from their companies in the wake of data incidents. So there's certainly things, evolving claims that and litigation risk that exist both to companies, but also to their directors and officers and to charities and to basically any organization. Next slide, please. So what lessons can you take from this evolving risk of litigation? The main ones are, the most important takeaways is you need to have an incident response plan and be prepared for something like this, because the reality is it's probably just a matter of when, not if you're going to have an incident. So an incident response plan is just a plan that basically dictates or guides you through your response when you are facing an incident like this. So you are not just making it up from scratch, because the first few days are very critical. And as Lynne mentioned, most of my practice is helping clients respond in those first few days and weeks and months. So those days are very critical. Just as a note, you should make sure to have a copy of your plan printed. I've had many clients have a plan and then not have a copy of it because their computer system was hacked, and so they don't have a digital copy of it anymore. So your plan is useless if you don't actually have a copy of it. So make sure you have a printed copy of it. Something to keep in mind is that you want to have internal and external teams as part of your plan, depending on the severity of the incident, of course. So some people you might want to consider including are what's called a breach coach, which is just a legal counsel. That's what I do. You will want to consider having a forensic investigator, which is basically an IT company that can help you respond. The expertise that it takes to respond and remediate from an incident that is cyber incident is different than your traditional IT person that you might have in-house at your organization, or that you might outsource to even. Like, this is a very specialized area. And you might want to have a PR company to help you with some of this stuff, and other providers. And I should note that a lot of these costs are often covered by cyber insurance policies, if you have a cyber insurance policy. So the cost of a breach, the cost of an IT expert, that kind of stuff might be covered by your cyber insurance policy if you have one. So highly recommend you consider like having the plan, and then including who's your point person on HR, who's your point person on finance stuff related to this, who's your point person on communicating, et cetera, et cetera. And a lot of those people should honestly be C-suite level people for the reasons I talked about, the director or officer liability, but also just because these are very critical type of incidents that can affect organizations, like the ransomware at Humber River Hospital that I mentioned. Next slide, please. So this is just a quote from a case from a few years ago involving Home Depot that had a data breach. And you'll see that the judge in this case says that there was no cover up, and Home Depot responded as a good corporate citizen to remedy the breach. Unless one wishes to play pretend, Home Depot was successful in resisting a pleaded claim of $500 million. And so that goes back to the $20,000 per person I mentioned there. And again, this just underlines the point that I was making, that how you respond is very important. And if you don't respond appropriately or quickly, you might have a very different quote than what's in this slide. But Home Depot in that case responded very well, and as a result, their response was extremely helpful in mitigating their legal risks. Next slide, please. Another thing, just to emphasize, I mentioned the legal breach coach or legal counsel acting as your breach coach, and one of the reasons for that is that why you want to have that kind of person on your team is for legal privilege. So as you may know, between a lawyer and a client, you have regular lawyer-client privilege, but you can expand that to include the IT company that I mentioned who can help you investigate, or the PR company that can help you with crisis communications, to include other people and therefore protect their work product from being producible in a litigation. So these three graphics here are just cases where because an organization set up their investigation of an incident from the beginning through their incident response plan with legal counsel or breach coaches, the courts found that the reports that they had received from their IT experts about what happened and what went wrong were protected from being disclosed. And that was obviously of significant value to them, because you can imagine what kind of things your IT person might say in an email about what went wrong. Oh, this person really should have changed their password, or we didn't have this patch enabled, or whatever. And that could be really damaging in the litigation. Next slide, please. So this is just a case. I'll briefly touch on it just really quickly. This is a case from a few years ago in the federal court involving the government of Canada. And you'll just see from this quote that the court is clearly aware of the big potential for privacy risks litigation is out there, and that underlines the slide I showed before with the many cases. I'll just quickly go, since I know we're running out of time, we're running short on time. I'll go to the next slide. So this case involved a government agency where they had the information about 583,000 individuals on a hard drive, and the hard drive was just lost. It wasn't stolen or hacked, or there was no proof that it was like found by somebody and used for nefarious purposes. It was just lost. But nevertheless, the government notified all those individuals, even though maybe arguably they didn't have to, as Daniel said, under the public sector law, but they did so. And they provided all those individuals 6 years of fraud flagging from Equifax and TransUnion. And they did a forensic investigation and looked on the dark web for any information that might have been impacted. And next slide. As a result of all that, they were inevitably sued, of course, and they did settle the case for $17.5 million. Which sounds like a lot of money, but if you think about it, it's really about $30 per person per the 583,000 people, which it theoretically could have been much higher if it was $20,000 per person. It would have been about 11 billion. So this area of law is still developing. There are some more recent cases that say that the $20,000 per person is not appropriate if you're not the one that actually committed the intrusion. But rather it was a hacker that did it. But nevertheless, the response and how you react can significantly reduce the amount of exposure you have as an organization. Next slide, please. This is just to quickly touch on the how you have to think creatively sometimes in incidents like this. So, the Government of Canada case I showed you and the Home Depot case are useful examples of how to respond for typical cases of maybe financial information being breached or personal identity information being breached, but that's not appropriate all the time, depending on what kind of information you have. So this case involves Aetna, where they sent they make an HIV and AIDS drug. They sent out letters to individuals related to that drug, but they used one of those envelopes that has like a clear window in it, and so you could see the person's name and thus realize the fact that they are, taking HIV and AIDS medication. And so that in itself was a breach. And so Aetna responded pretty creatively by, rather than offering credit monitoring or something like that, which probably doesn't make sense in the circumstances, they offered to reimburse people for counseling services or for any harm that might befall them, things like that. And that's just an example of how you need to think creatively depending on the types of information that are affected. And so again, that's why having an external person or having an incident response plan in advance can be really helpful, so you can think of these things. Next slide. So I already touched briefly on ransomware, but I wanted to talk about it in a bit more detail because it's probably one of the most common types of incidents. They're increasing in frequency. And as I discussed, the Humber River Hospital ransomware attack is a recent example, but there's dozens of those. If not hundreds. And the amounts, so just for anyone who's not aware, a ransomware attack is essentially where a hacker hacks into your system and then encrypts your files so that they're locked and you can't access them unless you pay them money for a key that will then give you access to the files. And so that's the ransom being paid. And the amounts being demanded are increasing drastically. A few years ago, it was fairly common to see maybe a $50 or $60 or $100,000 demand. Now it's frequently in the millions of dollars. There's a sort of a new exploitation tactic that's occurred in these cases in the last 2 years. Beyond just encrypting your files and locking them, they will also steal your files while they're in your computer system. And then if you don't pay them, they will put your files on the internet for everyone to see. And they can do that on the dark web or the regular web. And those websites are monitored by journalists very frequently, some of them. It's, they'll threaten, even if you can somehow get your files back without paying them, they'll now say that if you don't pay me, I'm going to put all your files on the internet, which can obviously have a significant reputational and personal impact on individuals as well as your organization. So the demands are, in the millions of dollars, partly because of this additional tactic. Quickly, I'll just note that, a lot of this is done by organized crime. Some of them are by sanctioned terrorist organizations. So these are sophisticated, attackers. And as a result of the increase in demands and increased frequency, governments are starting to focus more on ransomware. And there's going to be probably more guidance and more requirements in respect of making payments like this to such hackers in the future. Next slide. The other most common type that I see in my practice, the two most common are ransomware and then the one that's on this slide, which is an email compromise. Unfortunately, in addition to being one of the most common types, this is also the most underrated types or misunderstood types. People will often get wind of this kind of incident because one of their contacts will send them an email saying, hey, I got an email from one of your employees telling me to click a link or download an invoice or download an attachment. It doesn't make sense, kind of sounds weird. Maybe they were hacked. And then the company will say, okay, yeah, we'll change that person's password and then move on. But you're actually missing the big privacy risks that are underneath the surface. And the reason for that is that oftentimes when a hacker hacks into an employee's in email account and then sends emails like that, they also download the whole email account onto their personal computer. So even if you kick them out and change their password, they now have your whole email account on their computer that they could just go through all of the emails you've received over the last 10 years, let's say, being an employee. And so if you've ever received an email that had some sensitive personal information or a sensitive attachment, the hacker might have a copy of that. And most organizations will just not think of that and will kind of move on too quickly. And there's a serious privacy implications from incidents like that. Next slide. Lastly, just very quickly, I'll touch on the sort of the other common type of incident. This one, I've dealt with many healthcare charities that had this type of incident, which is not their organization being affected, but one of their vendors being affected. And so, maybe you outsource your HR or outsource your accounting to another organization, and they, as a result of doing that, you give them some sensitive information, and then they have an incident. And so that's another common type. Oftentimes these vendors may not even tell you about that because they don't have a contractual or legal requirement to do so. All the laws that Dan mentioned apply to the organization that's in control of it, which a vendor is not considered to be in control of it. They're a service provider to you. And so they may not even have an obligation to tell you. And so what you seriously want to consider doing is in any contracts you have with vendors, including a clause that requires them to tell you about an incident like this that affects any of your information that you're giving them. Just the last slide now. Just some key takeaways. I know we're running really short on time. As we talked about, the risks and requirements are escalating, and as Daniel mentioned, they're likely to escalate more over time. You should, one point that I haven't touched on in great detail, but you should consider that as an implication of everything we talked about, is you should manage what information you're intaking and retaining. We've had many clients have incidents where it's related to information they took in from someone like 5 years ago, and they don't even use it anymore. And there's nothing worse than having to face a litigation or notify a person about information you're not even getting any value from anymore. So make sure you keep good care of what you're actually keeping and what you're taking in the first place. Another takeaway is, as we talked about, is make sure you have an incident response plan. That's a main one. And make sure that it's filtering down through to the right people. An incident response plan is not really useful if your main front IT person is not going to follow it. They need to be aware and know what they need to escalate to what person. We talked about legal privilege considerations. So again, that's really important because it can protect some embarrassing information that might hurt you from being producible in a litigation or a regulatory complaint. Escalation protocols, as I mentioned, that has to do with your IT person, making sure they escalate the right incidents to the right person. And then lastly, as I mentioned, cyber insurance can cover a lot of the expenses that you might have to incur in an incident like this. So you should strongly consider buying some cyber insurance if you don't have some. That's it for me. Sorry, we were a little over. If we have any questions, happy to answer them, either Daniel or myself.
Well, thank you so much, Daanish and Daniel. We do have quite a number of questions in the chat, and unfortunately, we don't have time to take them, but we will commit to getting answers to those who pose the questions, and if they're of the right nature, we'll circulate the questions and answers to all of you. So I want to thank you all very much for attending our 16th annual Healthcare Philanthropy Check-in session. Before we sign off, Terry, any parting words from you?
Thank you, Lynne. I just want to thank you for being the moderator. You did a wonderful job keeping us on track and for coordinating. It's always a pleasure working with the team at Fasken. So it's our privilege to be part of it. And thank you very much, Lynne, for doing such a great job.
Bye, everybody. I hope you have a great rest of your day.
Bye.